Good evening. On behalf of the Kennedy School of Government and the Institute of Politics, I want to welcome you to the 59th Edwin L. Godkin Lecture. The Godkin Lecture Series was endowed in 1903 to honor Mr. Godkin, who was the founding editor of The Nation magazine, and to provide for lectures on the essentials of free government, the duties of the citizen. Our speaker tonight joins a long and distinguished list who over the last 6 decades have included Walter Lippmann, Adlai Stevenson, Nelson Rockefeller, Pat Moynihan, Paul Samuelson, C. Everett Koop, and Derek Bach, among others. This year's lecturer, James Q. Wilson, is well known to many of you. Since 1985, Jim Wilson has been the Collins Professor of Management and Public Policy at UCLA. But before that, for 26 years, he was the Shattuck Professor of Government here at Harvard. And I can say, as a former colleague of his in the government department, that he has been sorely missed. Jim Wilson is the author or co-author of 13 books, the most recent of which, The Moral Sense, was published in 1993, and On Character was published in 1995. He served on a number of national commissions concerned with public policy issues, including the White House Task Force on Crime in 1966, chairman of the National Advisory Commission on Drug Abuse Prevention between 72 and 73, member of the Attorney General's Task Force on Violent Crime in 1981, and a member of the President's Foreign Intelligence Advisory Board from 85 to 90. In 1990, he received the James Madison Award for Distinguished Scholarship from the American Political Science Association. Jim has his A.B. from Redlands and his Ph.D. from the University of Chicago, and has received 6 honorary degrees, most recently from Harvard in 1994. Please join me now in welcoming back Professor James Q. Wilson as he delivers the Edwin L. Godkin Lecture.
Thank you very much. I'm very grateful to my former colleagues and continuing friends at the JFK School and at Harvard University for giving me the honor of this award and the opportunity to address you. I know as a person who attended Harvard or who's worked at Harvard for many years that the attendance at the first lecture is large. The attendance at the second lecture much smaller. The attendance of the third consists largely of your wife and 2 children who are grumpy about missing ER. A friend of mine, Pat Moynihan, who preceded me at this rostrum, was asked by me about how to deal with this problem of steadily declining audiences. And he said, the answer is very simple, Wilson. Give your third lecture first. I would if I only knew which were my third lecture. What I'd like to talk to you tonight about is hinted at my topic, It's Not My Fault, and the subtitle is Law, Science, and Personal Responsibility. And this topic grows out of my concern in speaking with Americans around the country that many people believe that American society is suffering from moral decay because there's been a decline in the willingness of people to assume and ascribe personal responsibility for their actions. In this view, widely shared, as many of you know, we are more likely than once was the case to deny guilt, to expect rewards without efforts to blame society for individual failings, and to exploit legal technicalities in order to avoid moral culpability. What I want to do this evening and over the next 2 evenings is to assess one count in this indictment, namely the argument that the legal system has become excessively tolerant of excuses. I want to begin tonight with a discussion of how the law shapes self-control, continue in the next in an analysis of how it defines self-defense, and ending on Wednesday, if any of you are with me then, with an explanation of the necessary tension within all of us between the desire to judge and the desire to explain behavior. Social science seeks to explain behavior. The criminal law seeks to judge it. The general principle of Anglo-Saxon law is that people are responsible for their actions, but to this rule there have been added, by necessity, convenience, and a sense of justice, a number of exceptions. For murder, those exceptions, those excuses include justifications, such as self-defense, excuses such as accident or insanity, and mitigations, such as causing a reasonable person to lose his or her self-control. These exceptions were all originally designed to moderate severe penalties, for example, to excuse murderers from the gallows. But they have over time created an opportunity for medicine and social science to explain criminal behavior generally by expanding on whatever mental states may lead somebody to lose self-control, to enlarge on what constitutes self-defense, and to explore more broadly what might constitute a provocation. The result of this tension has been an imbalance between judging and explaining a killing, with the result that in many cases, not as many as most critics claim, but in some cases nonetheless, that we get a criminal law that punishes conduct only to the extent that it was the result of an action of deliberate hostility, of malice, or malice aforethought, or arose without any one of a list of approved exceptions. Science is an imperfect enterprise. It seeks to explain behavior. The criminal law is a sterner standard and seeks to judge that behavior. Science seeks causation, tries to explain motives. The law demands responsibility and tends to discount motives. The central failing of American criminal law is not the adoption of endless abuse excuses, but the relaxation of the desirable barrier between imperfect science and commanding law, with the consequent admission into testimony of questionable experts. Let me begin on November 27, 1978, when a young man named Dan White picked up a revolver, extra bullets with which to reload it, snuck in through a window into the San Francisco City Hall, found Mayor George Moscone and killed him, then reloaded, found Supervisor Harvey Milk and killed him as well. He was promptly arrested. When he was examined by a psychiatrist, immediately after the shootings, he showed no signs of psychosis or delusion. He certainly seemed able to appreciate the wrongfulness of his act. There was no evidence of insanity, provocation, or self-defense. To the police, it looked like a dead-bang case of premeditated homicide under the California law. But the jury thought otherwise. Dan White was convicted only of voluntary manslaughter and sentenced to a little over 7 years in prison. This case became famous for two reasons. First, the riots in the city of San Francisco that followed the verdict, and secondly, the mention during the trial of Twinkies. Now, this mention came in the course of expert testimony by a defense witness who argued that White suffered from periodic bouts of depression arising from the pressures of his job, aggravated, in the words of Dr. Martin Blinder, from having ingested junk food. And so the alleged Twinkie defense was born. Now, in fact, if you look at the record of the trial, you will discover that the psychological effects of junk food were not explored at any length during the trial, nor, in fact, is there any reason to think that the jury attached much importance to Twinkies. It was a headline-worthy event, but not one, I think, that weighed heavily on the minds of the jurors. The verdict they reached was based on somewhat different grounds, though related to the Twinkie defense, and that was the grounds of diminished or partial capacity, or as it's sometimes put, diminished or partial responsibility. This standard of diminished or partial capacity was invented by the California Supreme Court and can be thought of as a psychological halfway house, halfway between insanity and rationality. Dan White, it was claimed by his lawyers, suffered from an abnormal mental condition that rendered him incapable of fully forming a malicious or premeditated intent to kill Moscone and Milk. The condition that prevented the formation of this intent was depression. If it existed, and if it influenced the jury to retreat from a murder conviction, it is of very little consequence whether this depression and the diminished capacity that flowed out of it had as its source junk food, job stress, childhood experience, or genetic endowment. It all came to the same thing. Whatever shaped the jury's decision in the Dan White case in 1978, that case ushered in an era of increasing public attention to excuses, real and imagined. Recently, Professor Dershowitz of Harvard has compiled a list of some of them in a book entitled The Abuse Excuse, and he lists, among others, drug and alcohol addiction, battered woman syndrome, black rage defense, having too many Y chromosomes in the male sex chromosome, mob mentality defense, pornography defense, post-traumatic stress disorder, premenstrual stress syndrome, rape trauma syndrome, steroid defense, and urban survivor syndrome. Richard Delgado and David Bazelon have proposed an additional one, the rotten social background defense. Dershowitz, I think, echoes the feelings of many Americans when he complains of our increasing resort to the abuse excuse and other, as he puts it, cop-outs, sob stories, and evasions of responsibility. Now, in my view, I think Professor Dershowitz's list is greatly exaggerated. Many, if not most, of these excuses, defenses, and syndromes have not, in fact, worked for the defendants who tried them. Colin Ferguson's lawyers urged the Black Rage defense after he shot and killed several passengers on a New York railroad, but he rejected the defense, and the jury saw no reason to attach significance to it. No man in this country, I think, has ever been persuaded a court that having an extra Y chromosome should excuse or mitigate his criminal acts. Nor has, I think, any man beaten a rape charge on the grounds that just before the act he was reading pornography. What really settled White's case, and what underlies at a different dimension the arguments that Professor Dershowitz is making, is this doctrine of diminished or partial responsibility. Let me review for you for a few moments how this doctrine arose, what prompted it, and how it has been applied in the cases that I have reference to. Beginning in 1949 and ending in 1966, the California Supreme Court asserted that even an intentional killer might be guilty of nothing more than manslaughter if the murder that person committed was the result not of malice but of something else, and that something else was diminished capacity. The court asserted that malice existed only when a person was aware of the obligation to act within the general body of laws regulating society. In practice, this meant that the court had created a kind of halfway house between sanity and insanity. Someone suffered from diminished capacity if they were incapable of harboring malice because of mental disease, defect, or intoxication. One case that illustrates how the court developed this occurred in 1964 when a 15-year-old boy named Robert Wolfe wanted to use his home as a place to which he could lure similarly aged girls for purposes of sexual activity. And he realized the presence of his mother in the home was a substantial barrier to that activity, so that he got an axe handle, hit her over the head with it, and while she struggled on the floor to avoid his advances, he choked her to death with his bare hands. He then turned himself into the police. He pled guilty by reason of insanity. The trial court, however, decided that he was, in fact, sane, convicted him of the crime, and sentenced him to life imprisonment. On review, the California Supreme Court decided that the jury was entitled to find that the boy was sane. After all the facts spoke in that direction. He had planned his crime. He had concealed his early attempts to commit it. He admitted the killing was wrong. And he behaved calmly and coherently when confronted by the police. But it had great trouble sending what appeared to be a deeply disturbed youngster to life confinement. And so the Supreme Court decided that Ronald Wolfe knew the difference between right and wrong. That knowledge was, as they put it, vague and detached. As a result, again to quote their words, he was not a fully normal or mature, mentally well person, and therefore his conviction was reduced to second-degree murder. 2 years later, the California Supreme Court came back to this case in a matter involving William Connolly. Now note how William Connolly differs from Ronald Wolfe, because as the story develops, you will discover a pattern. The law, confronted with a difficult situation, not wanting to send Ronald Wolfe, age 15, to life imprisonment in California, invents a rule to keep him away from that. But the rule, once invented, requires a life of its own, and that life of its own begins to affect other cases, however different in relevant degrees. Now, William Connolly had been sexually intimate with a woman who finally turned him aside and announced she was going to marry another man. He complained of this to his friends, said that what he was going to do was shoot her and her to-be husband for her dereliction. He went off and bought a rifle with which to do it. He then practiced with the rifle in the woods, and finally, catching them outside of their cabin, he shot the two people to death. He did this not under any odd mental state, such as Ronald Wolfe had, and not because he was 15 years old. He was a fully formed, mature adult. He did this, however, while he was drunk. Accordingly, the California Supreme Court held that Connolly, despite having committed what otherwise would be a deliberate, premeditated crime, had been wrongly convicted of murder because he was drunk enough to reduce his capacity fully to understand his obligation to obey the law. 12 years later, we're back to 1978, and Dan White is on trial. And it is because of the accumulation of these cases, the Robert Wolf case, the William Connolly case, that the the trial court decided that depression was a condition of partial insanity, which would excuse the person from being convicted of homicide. As my colleague at the UCLA Law School, Peter Alarnella, was later to argue, this view opened courtroom doors to virtually unlimited psychiatric testimony, designed in large part to authorize a more subjective inquiry into the actor's, the defendant's psyche. By its rulings, the California Supreme Court has set in process a motion that would require juries to listen to expert testimony on the varying degrees of mental health of offenders so that they could attempt to match the criminal penalty to the psychological cause of the behavior that caused the penalty. By so doing, the appellate courts set in motion a process that rested on a most uncertain proposition, namely, the greater the degree to which a crime was caused, the lesser the penalty could be attached to it. Mental disturbance was such a cause, psychic depression was a cause, extreme youth was a cause, intoxication was a cause. And all of these causes, and others to be mentioned later, have commended themselves to various state courts around the country as causes of crime and thus as justifications for lesser penalties. Now, in reaction to the Dan White case, the voters of the state of California became quite upset and did what they usually do when they're upset. They get a ballot petition before the electorate, and they instructed the legislature to abolish the diminished capacity defense. The legislature, noticing that the people who were rather upset didn't even wait for this instruction, and by their own initiative in 1981, abolished the diminished partial capacity defense. But though that doctrine vanished from the statute books and appellate court records of the state of California, the underlying lesson of that doctrine, the principle upon which it rests, namely that a jury should consider all of the causes of the crime, persists, not only in California, but across the country. For example, recently there was a trial in the city of Los Angeles of young men who had been accused of nearly beating Reginald Denny to death with heavy bricks. At the time of their trial, their attorney said that they were caught up in a mob. And because they were caught up in a mob, they could not be convicted of either attempted murder or aggravated mayhem because the mob had sharpened their instincts to the point where they were no longer fully in control, no longer fully possessed with their self-control to moderate their actions. Now, this is an extraordinary development. If you think about the role of people and mobs, the first thing you recall is the Riot Act, which was invented in England and consisted of a document that the sheriff read out loud to a group assembled on the streets, telling them that if 12 men unlawfully assembled in a group, they were committing a felony, and therefore they ought to go home. Recently, however, the mob mentality defense has been used to make the defendant less culpable. And so Damian Williams and Henry Watson and others beat Reginald Denny nearly to death during the Los Angeles riots in full view of local television, but were not convicted of either attempted murder or aggravated mayhem because, being caught up in a mob, they had lost their self-control. Now, I have no doubt that being caught up in a mob causes people to lose their self-control. Whether the mob is composed of Ku Klux Klan members attempting to lynch a black, or blacks looking for a way to vent their anger at the acquittal of white police officers, or persons standing in dismay at Fenway Park watching the Red Sox lose another lead, or shoppers contesting one with the other in the basement of Filene's. All of these experiences cause you to weaken your self-control. And so also does suffering from depression, or post-traumatic stress syndrome, or taking high doses of anabolic steroids, or watching pornographic movies, or being a victim of racist behavior, or drinking too much alcohol. What I am suggesting, of course, is a rival argument. And that argument is this. We are all exposed to temptations in or out of mobs. We all on occasion lack self-control. Some of us face acute temptations or are remarkably deficient in our own degree of self-control. but it is the task of the law to raise, not to lower, the ante in these circumstances. The law is unkind to all of us when we are weak. It is especially unkind to those of us who are often weak. It ought to do so. It is the task of the law not only to remind us of what is wrong, and after all, most lawbreakers know in fact that they acted wrongly, but to remind us that we must work hard to conform to the law. Let me try to make this case in some detail with one example, and that is the role of intoxication in criminal defenses. Now, people who assault, rape, and murder often do so while under the influence of alcohol or drugs. Being drunk here or in England does not excuse one from the crime. The California Penal Code, like that of most states, is very clear on this score. No act committed by a person while in a state of voluntary intoxication, they do not clarify what involuntary intoxication might be, is less criminal by reason of his having been in that condition. This seems only reasonable. If matters were otherwise, people would be encouraged to drink even more than they now do before taking an axe to their mother or a gun to their sweetheart. But the law rarely leaves a judge uncontaminated by complications, and the complication here arises out of the definition of the legal idea of intent, and in particular an obscure, but it turns out extremely important distinction between general intent and specific intent. Now bear with me. This is complicated, but it's important. For example, in many states, rape is a general intent crime, by which is meant that a person is guilty of the crime if he willfully did that which the law prohibits, namely commit a rape. By contrast, a specific intent crime is one in which the defendant must be shown not only to intend a crime, but to intend a further result of that crime. For example, assault with intent to rape is called a specific intent crime. You can convict the person of assault because they were committing the assault, but if you want to convict them of assault with intent to rape, you have to be able to show that while committing the assault, they in fact intended to rape. Now, how that works out in practice can be revealed by the story of J. Lawrence Gouillet, citizen of the state of Michigan, who accompanied a woman to a tavern where they drank. He then took her to his house where they drank some more, and he began to make indecent advances, which she repulsed. She got up off the sofa, he knocked her to the floor, and he continued, in the words of the court, his attempt to commit rape. She hit him over the head with a telephone receiver so forcefully and frequently that he required hospitalization. And finally, escaping his clutches, she ran and called the police. At his trial, the judge told the jury that intoxication in this case was no defense to the crime, and so they convicted him of assault with intent to rape. The Michigan State Supreme Court took a look at this and reversed the conviction because the judge had failed to tell the jury that intoxication is a defense to a specific intent crime. That is to say, it is a defense to the argument that he assaulted her with intent to commit rape. The California Penal Code, like the Penal Code of many states, makes this distinction a matter of black-letter law. Evidence of voluntary intoxication is admissible on the issue of whether or not the defendant actually formed a required specific intent, or premeditated, or deliberated, or harbored malice or forethought when a specific intent crime is being charged. I confess to be somewhat at a loss as how this distinction is maintained. I confess to be something at a loss as to why intoxication, or indeed any other mental state, is relevant to judging the specific intent, but not to judge the general one. In fact, the distinction here is a fiction. It is a fiction designed to help a drunk offender evade full responsibility for his actions. Let's return to the case of J. Lawrence Gouillet of Michigan. What did the Michigan Supreme Court think he was doing with this woman? He pawed at her, he tore at her clothes, he knocked her to the floor, he pinned her down. In its own opinion, the Supreme Court said that in its view, he was probably attempting to commit rape. That surely seems a reasonable inference. If the appellate court believed it, why did they think the jury should believe otherwise? The distinction between a crime and an attempt is this. If I rape you, I obviously intended this because I don't think anybody does this by accident. But if I try to rape you, you must prove that I was trying to do so. Now that's a reasonable distinction. But is not the best guide to what I was trying to do, what action I was trying to bring into being, my own behavior at the time. Can you not more reasonably infer my intention from my behavior than from assumptions about the likely or unlikely effect of intoxication on my intent? To be sure, juries will be faced with ambiguous cases in which the person's specific intent is not entirely clear, but it's very hard to think of another interpretation to place on those of J. Lawrence Gouillet. Well, let's suppose there was some other interpretation, however. Let's suppose his pawing and groping and hitting were only meant to convey a desire to hold her hand or give her a kiss. Is our knowledge that he had been drinking relevant to determining the desire? No more, I think, than knowing his testosterone level, the extent to which he is obsessed with sex, or the power of her perfume. If intent cannot reasonably be inferred from behavior, then ascertaining his inner chemistry will not, I think, in most cases supply the missing link. But let's suppose that we do think that intoxication has some effect on his behavior. It may have led him to attack her, but we are precluded from thinking it led him to attack her with the idea of committing rape. Why should we assume that one's blood alcohol level should have an exculpatory and excusing effect? Isn't it equally plausible to assume that Lawrence drunk formed an intent that Lawrence sober would not have formed? Being drunk when you commit a crime is often regarded as depriving a person of the intent to commit a crime. But where that rule holds, you cannot be guilty of a crime if the necessary element of that crime is committing it intentionally, knowingly, or willfully. And so a drunk who steals a gun, steals at gunpoint is not guilty of robbery if he was too drunk to, quote, entertain the necessary intent to steal. He was simply holding the gun on you because it felt good in his hand at the time. One who assaults a woman is not guilty of attempted rape if he was so drunk as, quote, to be unable to entertain the intent to have sexual intercourse, close quote, against her will. Please forgive me if I have difficulty understanding what is being said in these appellate court opinions. Is a man trying to have sex with a woman ever so drunk as to be unaware that he's trying to have sex with her? And if he is aware of it, how can he be said to lack the intent to have sex? Now, some states have ruled by statute or case law that voluntary intoxication cannot excuse a person even from a specific intent crime. By my count, roughly half the states have this rule, about half the states have the other rule. But the leading authorities on it, the author of one of the leading criminal law hornbooks, criticizes the states that have abolished the voluntary intoxication defense to a specific intent crime as clearly wrong. My view is very different from theirs. If voluntary intoxication caused, that is, made more likely the offense because it weakened the defendant's normal inhibitions, his normal self-control, it should be the case that getting drunk and then breaking the law reveals a willful lack of self-control sufficient to enable us to judge the person as guilty. After all, you can become uninhibited, you could lose self-control for countless reasons. If voluntary intoxication can lessen your responsibility, you are offering a defense that can be readily extended to any action taken by a person that has the effect of blurring his judgment or weakening his foresight. If getting roaring drunk before I attempt to rape a woman excuses my offense, what about working myself up into a comparable frenzy by watching a pornographic movie, or joining a mob, or participating in a disorienting religious ceremony? Now, one response is that alcoholism, unlike mob rioting or religious fervor, is a disease, perhaps one with heritable origins, and so the heavy drinker is not responsible for his heavy drinking. Something very close to that was announced by 5 justices of the United States Supreme Court when they said in an opinion which happily has since been reversed, or at least discarded for the moment, that alcoholism, quote, is caused and maintained by something other than the moral fault of the alcoholic, close quote. This view will come as great surprise to the millions of people who drink without becoming alcoholics, and the millions more who were once alcoholics, but by virtue of such programs as Alcoholics Anonymous are now sober. One would have thought that the law would have recognized those distinctions by rewarding the controlled person or the recovering drinker and penalizing the uncontrolled or self-indulgent ones. As I speak, the United States Supreme Court is getting ready to speak again on this subject. In Montana, James Egelhoff was convicted of murdering 2 traveling companions while drunk. They were found in the front seat of the car. He was found in the back seat. There was a gun with him. From the gun had been discharged 2 bullets, each of which had penetrated the skull of the persons in front of them. Now, Montana is one of those states where voluntary intoxication does not reduce criminal responsibility, but Mr. Egelhoff's lawyers persuaded the Montana Supreme Court that this was a mistake because it violated the federal Constitution for a state to prohibit a defendant from using his intoxication to show that he lacked a specific mental state, that is to say, a desire to commit deliberate homicide. We shall see in the near future how this comes out. Now, one rejoinder to the argument I'm making here, using intoxication as an example, is that I have not spoken very much about the insanity defense. The insanity defense is common throughout Anglo-Saxon law. For the federal law and the law of most but not all states, it's akin to the MacNaughton Rule, which is adopted by the House of Lords in England in 1843. At that time, as many of you know, a person can be judged insane when he committed the crime if it can be shown that he was acting under some defect of reason or disease of the mind so that he did not know the nature and quality of his act, or if he did know the nature and quality of his act, he did not know that what he was doing was wrong. Now, there's a great deal of conceptual ambiguity in this rule, and it has been subject to all kinds of searching criticisms, most of which have had relatively little effect on its application. And I think that's had relatively little effect because when juries are handed an insanity defense, they tend to make the following judgment. Is this person crazy? And they use the common man and common woman standard of what constitutes crazy. That is to say, is this person suffering from hallucinations? Is he suffering from delusions? Is he the victim of schizophrenia? Now, from a scientific point of view, this isn't a very credible enterprise. From a scientific point of view, we must recognize that there are many mental states, from the purely lucid to the utterly delusional, which affect a person's behavior. One might be depressed or enraged or panicky or frightened, and therefore do things one would ordinarily not to do. Mental health is not a bipolar state. You're not either perfectly lucid or totally crazy. It is a matter of degree. Now, that criticism is very good science, but it is also very bad law. It is good science because it points out unequivocally that behavior is caused. It is bad law because it implies that the degree to which a person's behavior is caused, he is not responsible for it. The effort to enact into law the good science quickly revealed why good science does not make good law. For example, Judge David Bazelon some decades ago proposed in the case, the Durham case, which enjoyed some brief public attention, a new version of the insanity defense. In the Durham case, Judge Bazelon said that a person was not responsible for his actions if they were the product of a mental disease or mental defect. The product of a mental disease or mental defect. Now, psychiatrists liked this decision because it meant that there would be virtually no criminal trial in which their testimony would not be needed. Lawyers had a very different view, and rightly so. Any mental state, usual or unusual, could become a disease or defect. Almost any action could become a product of that disease, that mental state, to the extent there was any correlation between the action and the mental state. What had been lost sight of in the effort to convert good social science into bad law is a common sense view. That common sense view is that a person is responsible for his actions unless those actions were utterly beyond his rational control. And they were utterly beyond his rational control if they were the result of a pure reflex, an involuntary movement over which he had no voluntary control, or some delusional state. As these criticisms sank in on the American criminal law, the Durham test was rejected by the courts, including by Judge David Bazelon's own court, and in 1984, following the attempted assassination of President Reagan, Congress adopted for the federal criminal courts something very close to the old MacNaughton Rule. Imperfect as it is, the old 1843 MacNaughton Rule, I think, gets very close to being exactly on the mark. In this, I am joined by the psychologist Paul Meehl of the University of Minnesota, who's written very knowingly about it, because the old MacNaughton Rule, did he know whether the action was right or wrong, focuses one's attention on the extent to which a person was crazy, that is to say, was living in a delusional or hallucinatory state. to think clearly about why it is good law to have a bit of bad social science elevated into the status of the insanity defense, it is very important that you grasp, that we all grasp, the profound difference that exists, or should exist, between causation and responsibility. One can concede, in fact, if one is an ambitious social scientist, one will proclaim that all action is caused. That is to say, if one knew enough about the antecedent conditions of some given act, one could completely explain that act. By explaining the act, I mean you construct a theory as to why it occurs, you apply the theory to a wide variety of cases, you note that in all the cases, or at least the vast majority of cases to which you've applied it, the theory is confirmed. You say, we have explained this behavior. For example, if I strike your knee with a small hammer at a particular location, your leg will jerk upward. This is the patellar reflex, and doctors do it to you all the time. It's an involuntary act based on a heritable disposition. Things get a good deal more complicated when we try to explain intentional behavior as opposed to reflexive behavior, when we try to explain thought or speech or social action. But there's no reason to think that these actions are any less caused than is a patellar reflex. If we knew enough about my genetic endowment, my childhood socialization, and the opportunities and above all the incentives that the John F. Kennedy School has waved before me, and about the beliefs and principles by which I evaluate those opportunities and incentives, I think we could fully explain why I'm standing here delivering this lecture tonight. It might be harder to explain why you were here sitting listening to it. That's a different matter. But suppose we did fully explain my delivering this lecture, or Dan White shooting George Moscone and Harvey Milk, or Damian Williams hitting Reginald Denny with a brick. Would we then say that I and Dan White and Damian Williams were not responsible for their actions? Clearly not. The reason is not simply that we have no tested theory of human action that will, in fact, explain our behavior. Indeed, someday we may have such a theory. Nor is the reason that we assign responsibility for these actions because the law must rest, of necessity, on some convenient fiction, on a useful myth, the myth of free will. I don't think a legal system, and the society upon which a legal system depends, could long endure if they depended at the root on some invented myth. It is not a myth. In our daily lives, in our ordinary dealings with the average citizen, each one of us assigns to others blame and credit for their actions, even when we can explain their actions. Indeed, especially when we can explain their actions. And we don't do this because we are lousy social scientists or eager accomplices in myth maintenance. We do this because we really believe that people can be held responsible for all but a relatively small number of acts that are truly involuntary or the product of manifest duress. Why do we cling so stubbornly to this belief that blame and approval can attach to actions even when we can explain the actions? One explanation given by the legal philosopher Michael Moore at the University of Pennsylvania is that if we were to act otherwise, we would invite an absurdity. If all behavior is caused by factors beyond the actor's control, and if people cannot be blamed for actions that are the products of factors that are beyond their control, then nobody can be blamed for anything. This result strikes almost everybody as absurd, so we reject it. Or at least we reject it in our daily lives. But on what grounds do we reject it? I think it's because we use the word cause in this construction in a different way than philosophers use it when they talk about causes in social and physical arrangements. We recognize that some human action, like the patellar reflex or the epileptic seizure, is caused by processes over which people have no control. But all intentional human behavior, speech, thought, social action, is caused by the interaction of a genetic endowment, social learning, and available incentives. And these last two components, what we have learned through society, how we evaluate those principles on the basis of our own standards, are things that we have applied to the action. And so we are capable of making, with respect to other people's behavior, a judgment. We can say, when he did X, he knew better. Or we can say, when he did X, he ought to have known better. When your 10-year-old son hits his 5-year-old sister, because he thought you weren't watching, You hold him responsible because he knew better. When the boy hits the girl because he always hits her, even if you are watching, then you say he ought to have known better, or at least somebody sitting in for you will clearly say this if you don't say it yourself. But when a 1-year-old hits his mother, we say he doesn't know any better. And if we are good parents, we try to teach him to know better by restraining his blows and saying things like, don't hit. We insist on personal accountability because we insist that people beyond a certain age are moral agents. They are capable of moral action, even though moral action is often very difficult. If they break the law and cannot reasonably claim one of a small number of defenses, then they ought to be held accountable. Not only does this view satisfy our moral conviction that people ought to be responsible for their actions, it serves 2 additional practical functions. First, holding people accountable sends a message. And the message is that people who are learning how to behave ought to acquire those habits and beliefs that facilitate their conformity to the essential requirements of living in a civilized society. And it sends a second message. And that message is that when we hold a strict view of personal accountability, we are telling people who are choosing between 2 alternative courses of action, one good and one bad, that there are important consequences that are likely to follow with some degree of probability between choosing the good and the bad course of action. In short, we want to tell people that what you have learned and how you evaluate consequences will inevitably be part of an explanation of your behavior, except for those few involuntary reflexes or those few forcibly compelled actions. Since what you learn and how you evaluate it can be changed, learning and evaluation, though causes of your action, are also part and parcel of your responsibility for that action. Oliver Wendell Holmes, as usual, put the matter briefly, bluntly, and baldly. Our limitations on free choice, enforced by the law, fall most heavily on those who are most likely to err by temperament, by ignorance, or by folly. There are certain conditions that will excuse an otherwise criminal act. They are essentially of 2 kinds. Those that make the act involuntary, those that make an act of delusion. If you are unconscious, or under the threat of death, or under the threat of grave bodily injury, these are examples of involuntary behavior. If you have a defect of reason such that a person can't tell the difference between reality and delusion or between right and wrong, that is the meaning of the second excuse. Dan White was distraught and unhappy. He may have been suffering from depression. Possibly the depression was caused by Twinkies, though I doubt it. Damian Williams and Henry Watson were caught up in a mob frenzy. Patty Hearst was persuaded by her captors to help them rob a bank. But most people who are distraught and most people who are depressed do not kill. People who are in mobs may become rowdy, but most of them do not hit people over the head with bricks. Some kidnapped victims may be forced by murderous threats to commit illegal acts, but few are simply persuaded to do so. In short, White and Williams and Watson and Hearst were not delusional, and no one was holding a gun to their heads. A complete analysis of the behavior of these persons and others that I have alluded to might convince us that we had explained their behavior, and thus that their behavior was entirely cause. But cause is not an excuse, except insofar as the cause deprives the person of reason or forces the person to act. That is why the law has traditionally limited excuses to clear cases of lack of choice or clear cases of lack of reason. As Michael Moore again has put it so well, no cause is an excuse unless it destroys or seriously impedes our capacity for practical reasoning. A goal of the legal system is to foster self-control by stigmatizing and punishing its absence. Most people possess enough self-control to refrain from any serious form of criminality. But some observers wish to reduce the punishment of people who seem to lack self-control. There are 2 things wrong with this. The first is that excusing failures of self-control will increase the presence of the absence of self-control. The second is that once we leave the narrow excuses of duress or insanity, we will have, in the main, a vast list of the causes of crime, causes which, if seriously scrutinized, will lead us, I think, irretrievably to the conclusion that we cannot base an analysis of crime on its causes. Let me mention very briefly some of the factors that have been found by competent social scientists to be powerfully related to engaging in high rates of serious criminality. They include, in no particular order, having a low verbal IQ score, having a low level of the neurotransmitter serotonin in your brain, having a low level of monoamine oxidase, having elevated levels of testosterone in your bloodstream, or lead or manganese in your central nervous system, having a heritable disposition to alcoholism, being the victim of the XYY chromosome, suffering from fetal alcohol and fetal drug syndrome, having a mesomorphic body type, having a lack of religious involvement, suffering from extreme poverty, living in a single family, and the list goes on. In fact, many of these factors have a clearer relationship to the causes of crime than do those factors with which the courts have actually wrestled, such as post-traumatic stress disorder, or premenstrual syndrome, or intoxication. Why are some causes recognized and others ignored? I suspect that the chief reason is that some defendants seem more appealing or their defects more tempting than do others. That those are not good enough reasons will become clearer when I discuss tomorrow night in some room in this building the efforts of Eric and Lyle Menendez to avoid a murder conviction. Thank you.
Jim has agreed to take a few questions, but I should use this opportunity both to advertise and to fence off the subjects of the next lectures. Tomorrow night, self-defense in Starr Auditorium at 7 o'clock, and Wednesday night, law and responsibility also in Starr Auditorium at 7 o'clock. So without having complete previews of coming attractions, we will have a chance for a few questions now. There are microphones here and here. Yes.
Good evening, Professor Wilson. Thanks for coming to the Kennedy School. I'm Jim Haskell, second year at the Kennedy School. And I was very interested in your talk, and I would like to know, you didn't touch on you implied, I think, that it wasn't always this way, and I'm wondering if it wasn't, do you agree with that? And if it wasn't, what caused the shift in the law in attitudes about responsibility?
That is the subject of my third lecture.
Okay.
And you summarized it very accurately. And I will try to show how courts struggling with real problems, not imaginary problems, and not reading bad social science, came to apply new doctrines to criminal defendants, in large measure in order to avoid overly harsh penalties being imposed on them. But once you find a rule, whatever the motive for the rule outlives the motive. And that's what I was contending with today. More Wednesday. Yes, Harvey.
Your answer to that last question has an implication, which is that the more severe the penalties that you impose, the more likely these sort of evasive actions on the part of courts are likely to occur.
Mm-hmm.
Given the present climate regarding the increase in severity of penalties for all sorts of crimes, are we facing a kind of a descending spiral?
Let me repeat Professor Brooks' question. If the severity of the penalty induces some judges and some legislatures to moderate the penalties, would the increasing level of severity of penalties in the United States be having this effect? I don't think I can give a simple answer to the question because the answer would vary so much by state. I can say a little bit about California, where the formal penalties, at least until the passage of the 3 strikes and you're outlaw, which occurred a year or so ago, were not very great. If you, to quote a piece of research done by a colleague of mine, if you take a random sample of all of those persons arrested for having killed another person without justification, all the homicide arrests, and all of the homicide arrests that resulted in a guilty verdict either by a plea or a verdict by trial action, and then you ask, how long does a random sample of 100 murderers spend in prison in the state of California? The answer right now is 3 years and 7 months. Nationally, it's just under 6 years. We have a large death row population around the country. California has a substantial number of them. More of them die of old age than of any other cause. And so I think that this factor of the revival of the death penalty probably plays a role. But if you look at ordinary homicides, men killing wives and wives killing boyfriends and neighbors fighting over a tractor and shooting at each other, you discover that today the penalties are not severe. And in fact, if you look at the best research I know about in the U.S. prison system, which now unfortunately only goes up to the late 1980s, the rise in the prison population in the United States has been the result in large measure only of the crime rate plus an increasing percentage of convicted persons going to prison. It does not rest upon lengthening sentences. In fact, the sentence for burglary today in the state prisons is about 25% shorter than it was in 1950. Yes.
Professor Wilson, my name is Philippe Poudard. I'm a first-year student here at the Kennedy School, and I've just noticed that there's been this push to try minors as adults in our legal system, and I've been grappling with this issue. I'm not certain where I come out on it, of how much responsibility certain individuals in our society should have for their actions, particularly urban youth who grow up in very difficult situations. And I'm wondering, at what point do you hold them accountable for their actions? At what age? How severe are their actions, et cetera?
Well, those are all very good questions, and I haven't clarified my own thinking on that. We know precious little about how young people are now treated in the 3,000 counties and 50 states of the United States, because there is no central repository of information about what happens to juveniles. We know in some states they've passed fairly tough laws, but we don't know whether they've been applied. I'm struck by how rarely it is that tough laws ever get applied. I think legislators have discovered by long experience that voting noisily for a tougher maximum sentence has no effect on the crime rate or on the time people actually serve, but it does do them wonders in the polls. I don't know. My general view is that what you should do is try to find out how long two people, say one age 15 and the other age 22, on below the juvenile age and above the juvenile age, actually serve for common offenses. Now, I haven't seen this done in the United States. The Los Angeles Times tried to do a survey for the state of California and found that if you hold roughly constant the crime, the juveniles under the juvenile system are now spending more time in custody than the adults. Whether that's true in other states or even whether it's true in California, I cannot be sure. The general rule of law is that under the age of 7, a person cannot be held responsible. Between the ages of 7 and 14, a person can or cannot be held responsible depending on the courts, and above the age of 14, a person can be held responsible. The age at which young offenders are committing very serious homicides today has fallen so dramatically that I think it's very worthwhile trying to find out what happens to 14-year-old killers. And at the present time, I don't know, and therefore I have difficulty giving you a direct answer to the question.
Yeah, Professor Wilson, you mentioned earlier in your lecture that good social science makes bad law. Maybe, maybe not, but bad social science will always make bad law. Mm-hmm. And I'd like to kind of ask you, how come judges are being bamboozled by a lot of pseudo-social science? And just give you one example. There was an article in the Gazette a week ago or something about a book called The Divorce Revolution, which was sloppy research, and now it's being challenged, and now that research has influenced a lot of decisions all the way to the Supreme Court. And there is even the epistemology of social science is so much in doubt, and there is so much loose social science, and yet judges are paying so much stock and almost holding their common sense in abeyance.
Well, I'm going to talk a little bit about that tomorrow night, because in the case of self-defense, this is a crucial question. What constitutes the standing for an expert witness before the courts? testifying in behalf of somebody who killed another person but claims some extenuating circumstance. And the rules that qualify a person to serve as an expert are undergoing change, but in general they're rather broadly defined. Now, to anticipate what I'm going to say tomorrow night is that judges are guided primarily by the decision of other judges, not by what is written in social science journals. So that if you find a bit of social science that makes it to the appellate court level, let's say in New Jersey or California, and becomes embodied in appellate law, then other judges in those states, and in other states looking at those opinions, will adopt the court's decision as definitive and say, that bit of expert knowledge is in fact expert knowledge, and we will believe it. So that there is a gulf between the world of law and social science. It's quite wide. And the way you penetrate that wall is with the initial case. And in the initial case, it is, in my view, a bit of a lottery as to whether the person who passes through that initial case is a good social scientist or a bad one.
Thank you.
Would you comment on mandatory sentencing guidelines and how that has affected the situation you've described?
Mandatory sentencing guidelines vary so much across the country that it's hard to give you a general reaction. The Minnesota law is very different from the California law, and that in turn is very different from other laws. I think it has had the effect of reducing, in some states, the number of persons who can expect probation or a suspended sentence for a penalty, without at the same time changing dramatically the penalties that people get who would have gone to prison with or without the mandatory sentencing law. But that situation is very much in flux and is changing all of the time, so I don't want to take that as be taken as a considered answer. I don't think mandatory sentencing laws have had as dramatic effect on the criminal justice system as was anticipated by the authors of those laws. I'll be right back to you. Mark? Yes, sir.
I have a question that pushes beyond the law, sort of to the social, cultural context of law and to your theme for the night of self-control. And do you think that that we're lacking a kind of social, cultural tradition that makes the application of the issue of self-control what it ought to be? That law depends on other things for the reasoning, which probably incorporates some of your former work.
Yes, I do believe that. I do believe that the judges not only listen to the election returns, they listen to their own children and their colleagues in the club, and they pick up the common culture. And any culture that undergoes a transformation in the weight it attaches to self-control will affect the judiciary. That's inevitable. One of the interesting contrasts in this respect is between American judges and English judges who have responded somewhat differently to equivalent changes in the culture. And I think that change in American judges is a bit more pronounced because they are more exposed to the culture than are their English counterparts. But the change can be observed in both countries. Professor Moore.
Professor Wilson, it's a pleasure to see you again.
If the microphone is too high for you,
it is too tall. And they kept trying to get me to go to it, and I knew it would make me look short, so I hesitated. I've been actually trying to think about whether the material out of which one could plausibly construct a rotten social background defense for criminal culpability. And it occurred to me that there might be two bases on which one could do that. One possibility would be the discovery that, which is possible actually, that there's a relatively short period of time in which people could actually, in which they were open to learning a capacity for self-control and learning a capacity for empathy and learning a capacity for all the things that we associate with moral conduct, say, in a short interval in life. All right? That might be a social science finding. And then but it would only develop under certain conditions. And then one might ask the question whether those conditions were available or not. And if they weren't there, that might constitute the basis for a rotten social background defense. Now, that would be the moment in which science played a role in this. But one could equally well imagine that one could have constructed an argument that said either children were entitled or parents were obligated to do all the work that was necessary to build within children a capacity for self-control and for empathy and for learning how to do the right thing. And if the parents were unavailable to perform that role at the crucial time, that might turn out to be a defense, a rotten social background defense as well, on grounds that children who are entitled to the benefit of moral guidance, instruction, and assistance in reaching self-control and proper conduct didn't get it. And I wonder whether you have considered that as a possibility, as an answer to the question about what kinds of juvenile offenders we might find accountable or not accountable.
Yeah. You and I have had a bit of this conversation before, and I can't remember the clever answers I once had in this exchange. My view is that there is a serious problem in developing children into morally competent social agents. And the problem is getting worse in this and many other countries. But I'm not certain that the way to approach it is by redefining the legal mechanism that operates on the children once they come to judicial notice, which tends to be when they're teenagers. It may require that one redesign the juvenile courts to play a different role in the construction of parenting. Now, this is not impossible to do, though it is difficult to do for reasons you know very well, because they're underfunded, undermanned, underled. But it is also becoming difficult because of the drug addiction that parents are suffering from in juvenile courts, and the fact that a court order on them is a meaningless instrument. This is one of the great puzzles, and if it weren't such a great puzzle, you wouldn't be asking about it, because you're going to the core of the matter. I think that the law is not the instrument we should use for correcting a growing social failure. What other instruments we should use are ones that we can speculate about, but I think they require one to provide either the incentives for or the actual presence of an institution that will supply young children with an adequate start in life. And if parents aren't doing it, somebody else should, and the somebody else shouldn't be basically unlicensed foster parents.
Yes, I was wondering if you could maybe discuss the secondary effects, if any, that these changes in the criminal justice system may be having on our large urban police departments across the nation as they try to maintain order.
What effects will these changes have on police departments? I don't know. Give me a speculation. Do you have a guess as to what effect there are?
Well, just if you look at the late 1960s, some Miranda, Escobedo, MAP, some of the Supreme Court decisions that came out in the late 1960s demoralized police departments all across the nation because they hindered what the police thought is their ability to carry out their job. And I'm wondering, these are not as, I guess, publicly known because they're taking place in the state courts, but would they have, I guess, an equivalent effect on police morale?
Well, shortly after Miranda and Escobedo and other cases were decided, there was a small avalanche of social science research trying to decide whether they had a big, small, or a non-existent effect on police behavior. And the studies are in conflict. My general sense from having looked through them is that they had a significant effect with respect to what is often called, wrongly in my view, victimless crimes, drug dealing, gambling, prostitution, and the like, in which there was no complaining witness, and therefore the police officer was often at a loss to proceed with the case because if he advised everybody in their rights and supplied everybody with an attorney, nobody would say anything. My sense, however, is with respect to the kinds of crimes I'm talking about, violent crimes, robbery, burglary, and murder, they probably had, if any, only a rather small effect. And I think that I may be doing an injustice, but I do not believe that those cases are at the core of our problem. I think many of these cases were decided in the wrong way, or there are other mechanisms to achieve the same objective, but I don't think it lies at the core of the problem I'm talking about. And the police problem is not so much judicial intrusions into their search powers. The police problem, I think, arises more clearly from two things: difficulty in getting convictions and civil lawsuits against police action. Those two areas, I think, have a big effect on police behavior and a depressing effect on police behavior. Mark.
It's the convention of Anglo-Saxon as opposed to continental law that each trial is about a particular action, not about the character of the person being judged, it occurred to me that one reason why judges might want to think of some of these diminished capacity defenses was as a way of saying what they're not allowed to say by the convention, that this particular act was not characteristic of this particular actor, and therefore a long sentence based on this one act would somehow be either unjust or inappropriate. And I think as I listen to your list of the sort of social science explanations of crime that haven't been offered as defenses, they're mostly things that are fixed about a person. And so if somebody commits crimes because he has an extra Y chromosome, well, that's characteristic of him. That's not going to change. So is it possible that one solution to the problem you've raised for us is to get the character consideration back into sentencing in a more central way than it's currently allowed to? It's currently allowed to enter only through prior convictions.
Well,
probably not.
In most states, Professor Kleiman, the jury has substantial freedom to set a penalty by the distinction between first-degree homicide, second-degree homicide, voluntary, involuntary manslaughter, and does the prosecutor have wide discretion to charge with respect to those matters? So I think there's substantial freedom in it. And one of the things that disturbs me about some appellate court decisions is that after the jury and the prosecutor have done all of that and said, well, you know, this person was really bad or this person wasn't so bad, then the Supreme Court of the state says, well, but you failed to take into account this following possibility. I think that there has been an over-review of criminal actions by appellate courts, and that though the evidence code in most states says that the appellate court should defer to the trier of fact, the jury or the judge, with respect to all of the factual issues, in fact, they don't. And why they don't, I'm not quite sure. But they don't, and they do so less today than they did 30 years ago. I have time for one more question. Yes.
Hi, I'm Claudia Thompson, a student here at the Kennedy School. I'm curious if you've thought about whether the adversarial nature of the legal system here in the United States might play into this climate that creates an atmosphere where it's harder to create a sense of responsibility. And I was intrigued by your comment about England, and I don't know as much about the legal systems in Europe, but my impression is that many of the systems are more of a fact-finding nature and somewhat less adversarial.
The English system is much like ours, but the French and German systems are quite different, yes.
Based on that, or based on any research you have done, do you know if there are differences in the legal system itself, in the structure of it, and how adversarial it is that might contribute to this climate?
Well, that's a very good question, and I dug a lot in preparing for these lectures into readings on the French and German legal systems to find out whether they're what is often wrongly called the inquisitorial system, in which a presiding judge, after having satisfied himself to the facts, holds a trial which is more a general discussion of the background and circumstances of the person than it is a finding of guilt or innocence, whether that leads to significantly different penalties, better treatment. And the difficulty is that the evidence on which you can make such a judgment simply hasn't been gathered. And I think it would be very useful to try to take similar cases and in some way run them through the American and the German or the American and the French criminal justice system to see if you get different results. And you might well, but I don't know that that's ever been done.
I want to thank Jim Wilson for a wonderful start to this year's Godkin lecture series, and make sure that you keep some questions in abeyance, because as I'll remind you, tomorrow night at 7 and Wednesday night at 7, you'll get all the rest of the answers. So we'll welcome you to Star Auditorium tomorrow and Wednesday, but we want to thank Jim Wilson for a wonderful start tonight.
I wanted to ask a question about how much is going on. I've been trying to answer that. I've been struggling to answer that question. If I read more French and German, I might have a better answer.